Okay, let's go ahead and start. And as people start coming in as well, they can join in. Just a reminder, if you have questions, please ask them in the chat box and the question box on your screen, and we will get to all the questions at the end. This webinar is being recorded, so it will be available for full view on our website and all of our social media channels. Once again, this is Oghoorian. I'm with ACap Asset Management. We are a fee-only financial advisory and tax firm. And we focus predominantly on the healthcare market. Today, I have the pleasure of having Renee Noy from WorkWise Law join us. And I recently met Renee, and I was immediately impressed with not only her aptitude for employment law, but her just really pleasurable demeanor. And I asked Renee to come join us to do this webinar because she is an employment attorney focusing on all aspects of labor law, but she has a unique focus in working with healthcare professionals, which is why I invited her to do this webinar. And also, Renee is a preferred partner attorney firm for LA County Medical Association, the Cooperative of American Physicians, and the Physical Therapy Provider Network. So she is really intimately familiar with a lot of the issues that our clients are facing with healthcare and employment and how to navigate that really just complex web of different types of laws. A lot of employers, I think including ourselves, we are really reactive when it comes to employment law. We always tend to think of needing an employment attorney after something has happened, but it's really important to be proactive. And I think what's really sets Renee apart from most labor attorneys is that she is really proactive. She focuses a lot on what you can do as an employer before the problem starts, so that way you can get ahead of the game and prevent a more costly mistake later on. So without further ado, I want to introduce Renee, have her talk about her presentation, which is discussing understanding at-will employment. Again, this webinar is being recorded. Have any questions, we'll answer them all at the end, but please put them in. So without further ado, Renee, thank you for being on our webinar today.
Thank you so much for the introduction, Ara. I'm really happy to be able to do this. So today we're going to be talking about terminations. It's called termination considerations, the tardy assistant, the manager's attitude, and the coworker who may be too friendly with your clients. One of the biggest questions that we get at our law firm are questions about wanting to terminate and when people can terminate. So that's why I thought this would be a good topic. So how is it possible? Everybody knows that California is an at-will state. It's emphatically at will, and employers are able to hire and fire at their discretion, and yet employers are terrified at the thought of actually terminating an employee. So the reason is simple. Not only is California at will, but it's also the most litigious state in the country, and employees are very quick to run to an attorney's office on their way to an unemployment office. So while it's true that California is at will, this doesn't mean that termination can happen for any reason at any time. There are protected classes, and any termination that was based on an employee being a member of such a class is illegal. So before terminating an employee, it's critical to look at, whether the employer understands the applicable employment-related laws. 2, they need to develop and consistently apply appropriate policies, procedures, and handbooks. And 3, they need to document performance and disciplinary issues fully and objectively. Just like real estate agents always talk about location, 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 in our practice, we always talk about document, document, document. That is by far the most important preventative step you can take to make sure that you are protected as an employer. So what does that mean to understand applicable employment-related laws? So employers often mistakenly believe that at-will employment allows them to terminate anybody for any reason, but this assumption ignores basic anti-discrimination laws and other legal limits on discharging employees. At the same time, employees protected by these laws are not insulated from termination on legitimate grounds, such as like poor performance. So although it's impossible to list every cause of action that may arise out of the termination, some of the most common grounds on which employers face litigation risks include termination due to discrimination, retaliation, or harassment. So there are many laws that prohibit discrimination, including Title VII of the Civil Rights Act, which prohibits discrimination based on being a member of a protected class, whether that's your race, color, your sex, your sexual orientation, national origin, religion, other things like that. Of course, an employer can't discriminate against employees with disabilities. They're protected by the American with Disabilities Act. There's the Age Discrimination in Employment Act that prohibits discrimination on the basis of age, which depressingly enough is 40 years old and over. Discriminating on the basis of past, current, prospective military service, that's prohibited under another act called the Uniform Services Employment and Reemployment Rights Act, and that applies to all companies regardless of size. So another commonly litigated area revolves around discriminating against employees who are taking protected leaves. For example, the FMLA, the Family Medical Leave Act, that applies to companies with 20 or more employees, and that provides up to 12 weeks of leave. There's also protection for employees out on workers' compensation leave and disability leave. My partner and I are always amazed because when an employer finally makes that decision to terminate an employee, the employee oftentimes knows that they're on the chopping block. And coincidentally, this happens all the time, a day or two, or even on the day of the planned termination, where the employer has all the documents ready and they're ready to just terminate, they have their final paycheck ready to go, the employee ends up on some medical leave, whether it's a stress leave or they get injured at work or something happens where all of a sudden now they're not at work anymore because of some medical problem. Well, once that happens, we always get the phone call from the employer, well, can we still terminate? And the fact is that what we advise is that once that employee takes that medical leave, they're basically putting themselves in a very protected bubble. We always advise our clients not to terminate while they're out on the leave, because if they do that, they're setting themselves up for a really great retaliation lawsuit, disability discrimination lawsuit. But that's also why it's so important to document everything, because if all of the performance issues and the disciplinary actions and attitude problems that have been, if that has already been a problem with the employee and it's all been documented in their personnel file, then once that employee returns from their leave, you can terminate them at a much safer way and know that you're protected because you have all of that documentation in place. If all of a sudden you have all these problems with your employee and they're and they don't, there's nothing documented in there, and then all of a sudden they take a leave and now you want to terminate them, inevitably the employee will come back and say that you terminated them solely because of the leave they were on and it has nothing to do with their performance issues. So that's just something to always consider. If an employee seeks to enforce their wage rights, then they're protected under the Fair Labor Standards Act, which prohibits termination for exercising their rights. Besides protection by legislation, there's also protection where there's an employment contract that sets forth terms of employment. So these are just some of the applicable employment-related laws. I didn't even discuss whistleblowing, that's a whole other area. But all of these areas are things to consider when you're deciding whether or not you want to terminate an employee and exactly how to go about it safely. So the next thing is consistently apply your policies. So all companies should have an employee handbook. That's very important. That's kind of the 101 when you first start a company. And what that employee handbook should have is all of the policies of the office. This helps employees know what the rules and the expectations are. Proper documentation and implementation of an employer's policies and procedures are central to an employer's success in avoiding or defending against wrongful termination claims. It protects the employers because if an employee is violating a policy, and this is express grounds for termination, it's helpful to be able to point to the policy to show that there was a violation. Of course, the only way that this will be effective is to be able to show that the policy has been applied consistently to every single employee. If there's any inconsistency, then this gives the employee a very strong argument for discrimination. So, you have your policies, make sure that your employee handbook is up to date and that the employees know what the rules and expectations are in the handbook, and then apply it always to every single person the same exact way if you can. So when is termination appropriate? So employers, you have to ask these questions. Do you bear any responsibility for failing to appropriately prevent the conditions or address the circumstances that led to the termination? Have you given the employee an opportunity to address any problems that may have led to the termination? Have you properly documented and implemented your employment policies and procedures? Were the workplace policies properly communicated to the employee? Was there a thorough investigation of any potential misconduct? Have you applied any disciplinary procedures that are appropriate to the circumstances? And have the disciplinary procedures that have been enforced and applied consistently to all of the employees? So what, after you've gone through this analysis and, hopefully with an employment attorney to help you to make sure that all of the boxes have been checked and that you're properly protected. So then the reasons to terminate are this. First, if you have a toxic employee. So a toxic employee is somebody that has a general negative attitude, they're unwilling to take responsibility, they gossip, they waste time shopping online, or they're surfing the web. They have unprofessional or inappropriate communications, they're bullies, they harass coworkers. I have a great example of this. We had a client who called us. She's a physician. This is a very small practice. There's 2 employees. She's been running this office for close to 20 years. Well, for about 15 of those 20 years, she had this one employee. And from the very beginning, this employee was a problem employee. She was just kind of rude. She would question authority all the time. And then the doctor ended up bringing in a second employee. And the first employee was so rude to the second employee and bullying her all the time. This was going on for years. And this doctor, was very upset by this. She would go home every single day stressing out, didn't know how to handle it. And in fact, she did a lot of very proactive steps to try to fix it in terms of bringing in a facilitator that specializes in conflict resolution to try to talk to the 2 employees. She took them out to lunch constantly to try to air out the problems and have them discuss it openly with each other. Her last straw, and this shocked me, was that she took both families of the 2 employees and their families on a cruise with the doctor and her family. And she paid for all of this. And it was a nightmare because the 2 families ended up hating each other and they were fighting the entire time. So she was at her wit's end and she called me and she's like, I don't know what to do. And I could not understand how she thought that she didn't have to terminate this employee, but she just felt really guilty. So I advised her, you have to terminate her. There's no question. Everything had been documented. And so she did. And within, 2 hours of the termination, it was like a different practice. Everybody was so much happier. So the point being, don't ever waste your time on an employee like this, because if you've done, certain steps to try to fix it and it's just not fixable, you have to at some point let that employee go and just move forward. Every employee is replaceable. The second reason to terminate is obvious. It's just performance issues. Inevitably, when there's a employment lawsuit, the employer will always say that they terminated because of performance issues, and the employee will always say that it was because of discrimination. That's just the way these employment lawsuits typically go. And so that's why, again, you just always have to document everything. So what exactly does poor performance mean? Well, the questions that you have to ask in this situation, if you do have an employee that's performing poorly, you have to ask if you've accurately and objectively evaluated the employee's job duties and performance using well-designed performance reviews. Have you created a clear record of the employee's poor performance? And have you considered implementing a performance improvement plan to help the employee correct performance shortcomings? So obviously, as an employer, you do have an obligation to try to make sure that your employees have the tools and resources available to succeed. And if you're not giving them the proper training and the proper resources, then you're really setting them up to fail. And then you're putting yourself into potential exposure and liability if you do get hit with a lawsuit for discrimination or something along those lines. So you just want to make sure that you are always giving them the tools that they need. And as far as measuring their performance, we recommend for all of our clients that they do these performance evaluations at least annually, if not more, especially with the millennial generation. A really good idea to do it even more often than that, because the millennials are always seeking constant validation and any type of evaluation, the likes of Facebook and Snapchat. That's something that definitely translates into the employment setting. So with these performance reviews, it's also very important to be honest about them. If you are dishonest in your performance reviews, and then it'll come back to haunt you. If you're saying that, no, you did great in this category, and you're doing great in this category, but then verbally you're telling them, well, you do have some weaknesses, but overall you're doing a wonderful job. And if you terminate them later on and they come back with a lawsuit, they'll go back into those performance evaluations and say, well, you can't say you fired me for performance because I have these great reviews. So we always tell our clients to be very, very cognizant of that and to be honest in their performance reviews. So before you want to terminate an employee, you definitely need to consider your alternatives, because as much as I'm saying you need to terminate and cut ties with toxic employees, with employees that are having consistent performance issues, as long as you're documenting them, the fact is if you're able to find some way of not terminating, you're obviously in a much better situation, because you don't have to worry about getting hit with a lawsuit. So you want to counsel the employee on his or her behavioral problems, like really sit with them and try to have them understand what your concerns are and how they can fix it. There's these performance improvement plans that we draft for our clients all the time, which sets forth the expectations of what the expectations are in your office, and how they can get to that place and what they need to do. And if it requires outside training, if it's going to cost you a little bit of money to train them, it's absolutely worth it if you think that that employee will be agreeable to it and if they will be able to get that training. So I think that's a really good idea. Then you want to issue, if the performance is not improving, if they're having behavioral issues, attitude problem, they're not getting along with their coworkers or with you, then at some point, very quickly, you want to start having warnings. First, you just do a verbal warning, but even if it's a verbal warning, you still want to document it. You want to document everything. So if you tell an employee, you've been late, this is your third day in a row that you're late, they say, okay, yeah, I'm going to work on that. Well, then put a note in, just write a note. It doesn't have to be a formal document. It's just writing a note on a piece of paper saying, on this date, I spoke to this employee about her tardiness, and she said that she's going to try to do better, and then stick it in their personnel file. After you've issued the verbal warning, you want to issue a written warning to the employee where they sign off on it, just saying that, we spoke about this and now you're still having these issues, and you want to put the written warnings into the personnel file also. And then if it's still not getting better, then you want to temporarily suspend the employee with or without pay. It's obviously fact by every situation is different. Just you have to look at what the facts are before you make a decision as to how you want to proceed. You can always do a suspension, and then at that point, if you've done everything that you can, then you can terminate them. But you really want to try. I tell my clients all the time, because I have employers call me and they're like, I just can't stand this person. I don't want to look at their face anymore, and I need to get rid of them. And if there's not proper documentation, then I always tell them, just play the game and just pretend like you really want them there and do everything you can to make them feel like they're valued and that you really care about their success at the company before you actually terminate. It's all about preventing lawsuits and protecting yourself from all of the liability that comes with having employees and certainly with terminating employees. So once you've done everything that you possibly can do, and now you know that you really have no alternative and you have to terminate, so there's still steps that you need to take. So first, you need to make sure that you have all the necessary documentation ready at the meeting. So at that final meeting where you're planning on terminating them, you want to provide the employee with a termination letter and a severance agreement if applicable. We always advise our clients, if possible, to give a severance, because with the severance comes a release of claims, and you don't let them sign anything or you don't give them the severance check, until they've signed the release. And that release is very, very ironclad. Once they've signed that release, they really can't come after you. And that's really important. So if giving them a couple weeks severance is going to prevent you having to go through a lawsuit, it is absolutely worth it. We advise, in most situations, I think that's appropriate. You want to make sure you give the employee notice as to their employee benefits, such as COBRA and any pension plans or whatever, is applicable to your company. You have to give them their final paycheck. It needs to be an actual physical paycheck. You don't do a direct deposit of a final paycheck. And you make sure it has all of their bonuses or commission payments, if applicable, any accrued but unused vacation days, and any other paid time off. That all has to be in that final paycheck. The delivery of the termination message is very important to carefully consider. You want to take into account the timing and the location of the communication, who's going to be at the meeting to convey the message, the content of the message, and responses to anticipated questions from the employee, who may be sitting there totally in shock. They had no idea that this was happening, and it's a very emotional, very stressful time. But, we had a client that was terminating an employee and decided to terminate this employee in front of basically the entire staff, and it was humiliating. And he should have been terminated. I strongly supported the termination. I did not know he was going to do it in front of the entire company, and the employee ended up suing, and it was because of that. It was because he was completely humiliated. So you want to really consider all of that. Something that an employer can do that's not legally mandated, that is nice is to provide the employee contact information for the state unemployment agency if the employee would be eligible. You want to maybe provide information on counseling services or an employee assistance program, and provide information regarding outplacement services to help the employee find another job. It's just taking a few additional steps to show that you really do care about the employee as a person, even if you don't want them working for you. So those are really all of the points that you want to consider when you are thinking about termination. And if you have any questions, I'm happy to answer anything. You can write them in, and I'm happy to help with any further questions.
Wow, that was great, Renee. There are a lot of questions. I don't even know where to begin, but that was so informative and chock full of information. So I'm just going to jump right into it. I'm going to ask a few questions again as a reminder. If you do have questions, put them into the question box. We will answer all of them, or we'll try to answer all of them. And this is being recorded, so if you don't have if your question does not get answered, please reach out to us either by email or social media, and we're happy to answer any follow-up questions you might have. So let's go into it. Let's see what the first question is. It's related to the employee handbook. Does an employee handbook have any actual bearing on protecting a company from liability if they decide to terminate an employee? And I think we've had more than one question on the employee handbook. So if you can answer that one, I can jump into the next one too.
Yeah, I mean, we put a lot of emphasis into the employee handbook because it really just sets forth all of the expectations for the employee and what the appropriate behavior and expected behavior is, and how the office is supposed to be running. And as I said in the webinar, it's so important to make sure that all of the policies that are in there are consistently applied. But we always talk about making the employee handbook a living and breathing entity. If you just create that handbook and it goes into a drawer and it collects dust and it's actually not being referred to and not used, then what happens is you end up in depositions with the supervisors and managers, and you refer to a policy, and if they have no concept of what that policy is, they don't remember even looking at it in the handbook, and it really has no meaning. But if you can show, like, look, these are the policies of our office, this employee did not did not comply with the policy for this reason, it really gives you such a protection around you if they end up suing you for for being terminated improperly, when you could show that it was completely within the realm of what the policy stated and what the violation was.
So how often should employers be updating the employee handbook? I mean, is it something where it's an as-needed basis, or they should be on an annual basis, reviewing it and updating? What's the recommended frequency?
Every year, for sure, because employment laws in California change constantly, and in a handbook that's more than a year old is absolutely outdated, and there's going to be policies in there that don't apply. And I mean, just even just in terms of the sick leave and the issues regarding benefits and different medical leaves. I mean, those laws are changing, so you definitely want to be up on that.
Okay, now I've heard that the laws vary based on the number of employees an employer has. Is that true related to employment law?
Oh yeah. There's several magic numbers, but the big one is 5, because if you have a company with 5 employees, then that includes the owner. So if you basically are the owner with 4 employees, then all of a sudden the Fair Employment Housing Act kicks in, and once that law is triggered, then an employee can sue for discrimination. So all of the Title VII protections of gender and race and all of those things, that comes into play under the Fair Employment Housing Act. If you have less than 5 employees, then I think the law really kind of considers it as you're just trying to survive, and you don't have a lot of room to replace people. If somebody goes out on a medical leave, you can't really continue going without having somebody replace them, and you're not expected to have the same reasonable accommodations and bringing somebody back in. So once you have 5, then you have to be very careful about termination. But below that, you don't have to be as careful.
Okay, great. Let me get to the next one. If an employee has worked for a company for a short period of time and has not made it through the probationary period, is it safe to terminate them for any reason?
No, so we get calls all the time. We'll say, we have an employee and she's not great, and day 30 is tomorrow, and it's a 30-day probationary period, so we need to terminate right now, right now. And we always say, and it's true, that the probationary period really does not have much meaning of anything. The only reason the probationary period is even relevant is for purposes of when, if a company is offering benefits, when they're eligible for their benefits. That's when that probationary period becomes relevant. But besides that, you can have an employee work for a company for 2 days, and if they feel like they've been terminated wrongfully, they're going to sue you, and they have a right to sue you. But what I tell my client, I actually literally dealt with this a couple days ago, where one of our clients called us because they have an employee that's been working for them for about 3 weeks. They want to get rid of her, and they don't know what to do. And I said, look, I would, and she's now going on disability leave, so now that's the problem. And I told him, I said, you can absolutely terminate her while she's out on this leave, but you're opening yourself up for liability. But the other side of it is their damages are much smaller, because they really, they haven't been, an employee that's been working somewhere for 10 years is obviously going to be having a lot more of a lawsuit than somebody who's just been working there for a few weeks. That doesn't mean that they can't sue you. But the probationary period does not protect you in any type of wrongful termination case.
Oh, that's an excellent point. Okay, next question is also related to termination. Should I, the owner of a company, always first issue a verbal warning, then a written warning, and then terminate when it's strike 3? I don't know if you understand that question, but hopefully you understand it.
No, I do. So when in employee handbooks, we never put like a 3-strike rule, or we never say do this warning, then this warning, and then terminate, because you don't want to tie yourself to those types of restrictions. Because the fact is, every situation is very different, and in some situations, if an employee something that's seemingly egregious to another employee and you want to terminate, and in a different situation they may be really good friends and they may have a different type of relationship, and it doesn't really require immediate termination. You don't want to tether yourself to a system where this is first verbal, then written, then termination, because really, there's just, every fact pattern is very different, and people's attitudes and the environment and the problems and fighting, and they all just present themselves very differently. So the problem is, because we emphasize consistently applying the policies of the handbook, you really can't when it comes to discipline. So you don't want to tie yourself to that. So we don't ever list out, the process that specifically as to discipline in the handbook.
Okay, all right, great advice. Just the last 2 questions. One is, do performance reviews have to be signed by both parties?
Yeah, it's a good idea to have everyone sign it, just so that you can show that the person that gave the performance review in fact did it, and that the person that received it was there and present and signs off on it. I don't know if it's, it's not going to change much if you have, just the fact that you've documented the performance review. Nobody usually argues, well, I didn't have it, if in fact it's all been filled out. But it's just another protection to have everyone sign it, but it's not like a legal mandate or anything like that.
Okay, and the last question is related to the venue of terminating someone. You mentioned, obviously it's not a good idea to parade them in front of everyone and say this person's no longer working with the company, which, by the way, I've actually seen that happen before, and it was not a pretty experience for the person who was being terminated. What is a proper venue? How many people should be present at that meeting? What is it appropriate to have only the owner there, or maybe the owner and head of HR? What is the recommended venue and people that should be present?
I always suggest there should be at least 2 people in the room, and typically it would be the supervisor or owner, however the company is structured, and then have an HR person or office manager in there as well, just to act as a witness, and answer any questions about, what happens next in terms of, when they leave the company. Benefits and all of those, COBRA, whatever it is. I think it's good to have both of those people in the office. And then, sometimes there's security concerns. If there's somebody that thinks, if there's some hostile environment and you're worried that they're gonna do something, or just create a problem, and you want to either hire somebody from outside as a security person, or bring somebody from the building just to escort them out. But you want to be very aware of that, because in this day and age where people are, just seemingly getting crazier, I would definitely want to be aware of that.
Okay, Well, Renee, thank you so much for joining us. This has been really, really informative. Next slide has your contact information. If you have any follow-up questions, or if you need, if you're an employer, you need a great labor attorney, please reach out to Renee. This is her contact information. As I mentioned, this is being recorded, so it will be on all of our social media and websites. Renee, thank you again for participating, and we look forward to working with you again.
Thank you, Ara. I appreciate it.
Okay, everyone. Thank you for joining us, and have a great rest of your day. Bye.